thanks very much for joining us. Nice to have you with us on this Monday morning as we watch the markets, and it looks like it's going to be a positive day. We're also covering this developing story with Rogers. Before the break, Paul Bagnall, who's live in Vancouver ahead of this courtroom showdown. The Supreme Court of BC ready to hear both sides. Of course, this is not just a boardroom fight. It is literally Rogers versus Rogers. Family members pitted against themselves. In corporate governance circles, they'll probably be talking about this one for years because there have been so many what feel like unprecedented developments. Let's bring in Richard Leblanc, who's a professor of governance, law, and ethics at York University. He's joined us throughout our coverage of this developing story. Richard, nice to see you. And here we are with this big courtroom showdown. What are you going to be watching for today?
Well, there's three things that happened over the weekend that we learned about, John, that I think are very significant. Mr. Ted Rogers, in settling his estate, he desired regular chair rotation of the trust. He also desired a shareholder meeting to elect directors, and he also desired earnest consultation with beneficiaries of the trust. Now, I don't think very much of this has occurred. Loretta Rogers, in her affidavit, included an appendix of his wishes. And settlers' wishes are very determinative when it comes to trusts. So no doubt Justice Fitzpatrick will be looking at Mr. Rogers' wishes and Ted Rogers, and whether, in fact, Ed Rogers complied with those wishes.
And ultimately, since I know you're more the governance expert, not necessarily the legal expert, but you're well versed in these matters right now. Given that Edward Rogers and his legal team undoubtedly has had a chance to review that material before ultimately the courtroom showdown plays out, what kind of argument do you think we'll see put forward from his camp?
Well, it's difficult because the facts, I don't think, are on his side. From a corporate governance point of view, he was removed as chair of RCI. He was accused by other directors over the weekend of excessive micromanagement and going around the CEO to contact executives directly. That will absolutely wreck a board. That will frustrate a CEO and a management team. So, there's a saying in law that you want to come to the court with clean hands. It's difficult for him to argue some of the facts. The evidence, as I see it, is that there was very little consultation with beneficiaries, and he's now in the unenviable position. He's in front of a judge that has been called to the bar for 40 years, has 10 years of commercial litigation experience, is female. And three of his of other female beneficiaries are alleging that his conduct was inappropriate. So if I'm advising Mr. Rogers, and I'm not, I think his legal team would be arguing how he engaged in consultation and how he is seeking to avoid a shareholder meeting. They have largely lodged their arguments on technicalities. And up until Friday, John, I thought Mr. Rogers was correct that he could, using the articles and the BC statute, use Section 180 to have an ordinary resolution. But what introduces a wrinkle over the weekend is the trust and the desires of Ted Rogers and the interests of the beneficiaries.
Well, it was a helpful extra piece of context. Obviously, it has invited all sorts of analysis of how the Rogers empire was built and who controls it. But at the end of the day, I think a lot of people are just trying to figure out where things go from here. And we were just talking with Paul Bagnall about, the reality that running a big public company where, as it stands today, there is confusion on which board is in power, how long that can stay up in the air. Do you think we'll get a resolution today? If we don't get a resolution today, what does that mean? I mean, this company, as we've alluded to, they've got to do the day-to-day business. They're trying to get to the end of the line with this Shaw deal. How long can you have what feel like two different boards that are in power of a publicly traded company?
I agree with you, and I agree with your colleague that it's unsustainable to have two boards that claim to be valid. However, we've got three parties here: Mr. Rogers, his family members, and RCI that all have deep pockets. So I think even if we get a ruling this week, it will be challenged at the Court of Appeal. Mrs. Rogers has already said that she would challenge it. So even at the best of times, John, my advice to boards is, you've got to get behind and broker a compromise. And I don't think there's a history of that here. Even if there is a ruling, let's say there's a ruling in the next couple of days and there's one valid board. I don't believe that these directors, and I'm not picking on anyone in particular, can exhibit solidarity and resiliency to get behind and to support the valid board, whatever that valid board will be. So I think Rogers has downstream governance issues, even with the ruling. At the best of times, boards find it difficult to get past a dispute like this. But here we have entrenched family dynamics that will further exacerbate the ability of the valid board to claim authority and to go beyond and to prepare for the merger. So I think there's more shoes to drop here.
Just before I let you go, and hearing everything you're saying, I'm going to ask our control room if they can put up Rogers' stock price. And obviously, we have seen some of that uncertainty reflected in the shares. If I'm hearing you correctly, and that there's still ultimately will be a challenge in getting all sides on the same page based on whatever a courtroom decides or a judge decides. At what point does there have to be some kind of united front because there are other stakeholders in this story?
Well, that's exactly my point, is that the legal issue will not resolve this dispute. There needs to be behavioral modification, if you will, and getting behind the valid board, whatever that valid board happens to be. And I tell directors, if you can't do that, and many of them can't, you have to stand down from the board. I mean, you cannot be a member of a board with this constant infighting and breach of confidentiality and visceral dislike of other directors. I mean, so I think the more shoes to drop here are resignations beyond the valid board. What investors want to see is certainty. They want to see a board that speaks with one voice, not 14, and they want to see a board that has that gets along and is effective. And we're a far away from that, John.